This PowerPoint presentation has to deal with the selection process in the hiring of new employees and the promotion process within an organization and what is and what is not allowed by law. By discriminating during this selection process, it is governed under Title VII of the Civil Rights Act. It is because that employees are the backbone of any company, it is permissible to evaluate prospective employees through a series of testings, but these tests must be kept to a job-related situation. You are not able to discriminate because of age or family health issues, and it is not permissible to ask these questions during the selection process. You're not able to advertise through media or written of a particular class unless it is a bona fide occupational qualification to whereas it is pertaining to females, such as females being in a female situation where nudity might be present. But other than that, it has to, or in religion, it can be within a particular religion to promote that religion. To reiterate on the bona fide occupational qualification, it is such as promoting the religion, a gender situation, and these will satisfy the bona fide occupational qualification requirements. When interviewing applicants for prospective employment, it is illegal or not lawful to ask questions of medical problems, age, if they have ever filed a workman's comp claim, religious preferences, and as far as medical goes, terms of employment have to be offered, and then job-related medical tests can be taken to evaluate their capability. This slide shows an example of a generic information non-discrimination act where damages were paid of $50,000 that was solicited a family medical history of specific conditions. It was the first lawsuit filed by EEOC to enforce GINA, and it was filed on May 7th, 2013. If you would like to check up on it, these are the sources that you can. It's Day and Pitney, and contributor was Howard Fettner. It was written on May 15th, 2013, a couple of days after the case was settled. There's two guidelines that have their own governing bodies, that is the Age Discrimination and Americans with Disability Acts. These can qualify under a possible BFOQ, but of course, again, it has to be job related. And selection procedure is the term used during the hiring process that you can check on credentials, resumes, physical evaluations, and experiences that are solely job related to the applicant and the job that they are applying for. It is imperative as an organization to keep records of all your selection processes, your terminations, because if there is a claim filed against you through the EEOC, it will help you to be able to show how your process was and how your promotions, and it will save time and litigation. As far as promotional discrimination, again, it is unlawful to ask if married. You have to give them the opportunity to accept or decline the offer, But don't assume anything when it comes to job promotions, for this might discriminate against married or older couples, and let them make the decision. Nepotism, as far as hiring or promoting within family members, it is lawful, but otherwise, a lot of organizations don't like to, because it might open up a case of discrimination. But then again, you got to fall back to the qualifications of the persons that the promotion is being offered to, and let the record speak for itself. As an employer, it is your responsibility to check on information that's given during the employment process, because if there has been a incident of one of your employees having violent behavior in jobs past, and they're hired onto you, and they cause harm to property or persons, if you do not check on their history, you may be liable for any actions that they do as far as negligent hiring. And again, that will fall under the references. You could check out anything that was written down that the applicant wrote down on a resume or an application. It is imperative that you do check these references to make sure everything is on the up and up. This will keep you clear that if you checked out everything, and something happens, that it will limit the liability you are under if a tort is committed. When checking on backgrounds, some employers do not like to divulge much information, because they're scared it's going to set them up for a defamation claim. But as long as it is totally job related and truthful, there's nothing to be worried about.